Hello and welcome to Legally Speaking with me, Tarun Nangia. The past fortnight has been a very newsy fortnight. We had none less than the Law Minister India himself writing to the Chief Justice of India, where he spoke that, in a sense, that government should have a say in judicial appointments. Later, he retracted that statement. Some other statements were made that there should be a search and selection committee for appointment of judges, so on and so forth. That is point number one. Point number two, the whole issue of collegium and appointment of judges, which we at Legally Speaking, if you remember, have taken up even about 4-5 years ago with a panel including Dr. Singhi and others. And now is the time to revisit it. I have a very eminent guest joining me on this, a top counsel at the Supreme Court of India and also the president of the Supreme Court Bar Association. Senior Advocate Vikas Singh joins me. Good to see you, and looking forward to some interesting insights on this whole issue from you.
Hi.
At the very outset, I want to ask you, yesterday in the Indian Express, there was an article by Sriram Panchu, eminent mediator. He spoke on the Collegium issue. And taking off from that, would you want to make a few comments before we move on? So it's over to you for the opening comment.
So Sriram Panchu has, also been very firm that the Collegium system needs to reinvent itself. And while, justifying the law minister's letter, he says that why not the government also be part of the decision-making? Although the law minister apparently has not asked to be included in the Collegium itself. But if you recall, the NGSC was struck down because the government had a veto. Now, if the government doesn't have a veto, and if the government remains in a minority, but at least partakes in the discussion, I see no reason why the government should not be, but then that can't be done only by a legislation. It can't be done by a MOP, because MOP can't really, go against the judgment of the Supreme Court, which has, set up the Collegium system. So if you want to do it, you'll have to do it by a new law, and which I've been suggesting to the law minister to bring in. In fact, I've drafted the law also to him and given it to him. And he mentioned it in the parliament that he has got something from the president of the Supreme Court Bar, and he's looking into it. But Panchu also says that the president of the Supreme Court Bar should be included in the Collegium. Now, not that I want to be part of the Collegium, but I definitely feel that the Bar Association is one of the most important stakeholders, not only in the Supreme Court, but also in the High Court. So the Bar Association will be in the best position to identify the right people going forward. Now, even if you look at it from the larger perspective, if the best people go up and become judges, then obviously there is more opportunity for the people remaining behind. And so it is always in the interest of the bar that the best of the best go and become judges. But who amongst them will go and who deserve to go is a separate subject which we can discuss later.
Okay. I want to ask you this. You have spent more than 3 decades at the Supreme Court of India. You have seen various iteration of the judges' cases. Then you've seen the Collegium coming in place. You've seen the appointments happening. And now suddenly this whole issue cropped up after the law minister wrote a letter. If you could reflect on what has been happening and why what is happening today is happening.
So if you ask me the first question about whether Collegium is the right way forward, according to me, it is the right way forward, provided they work properly, provided they do their job properly. Now, judges, by their very, nature of their job, do not have enough time with themselves to, do a separate exercise of, screening people, meeting people, finding out who are the best in the profession. So accordingly, what they do and what they've been doing in all these years is that they go by people whom the 3 Collegium members know. And that invariably ends up in nepotism, that ends up, in selecting people of their, their juniors, former juniors, and their, castemen, etc., which is the bane of the Collegium system. And the problem with the people whom they know or people whom they see appear is also that that invariably is not the real talent which should be made a judge. So if a lawyer appearing before one of the Collegium member is arguing well, he most likely would be a candidate for being considered for being designated as a senior and being taken in that path, because the profession needs good lawyers in argument also. You can't have everybody becoming a judge and nobody remaining in the argument side. But there are a very large number of lawyers, who don't make it big as seniors and who are not, good at arguing and who are very good at drafting, who are very good at strategizing, who brief the seniors most of the time. And the seniors actually are arguing on the basis of what is briefed by a particular junior. Now, those are the people who are not visible to the judges. And those are the people who really deserve to be considered for elevation, because they are the line for becoming a line where they will be just below the big league. And they will definitely be interested in taking judgeship also. And they are not identified. Nobody is identifying them. Nobody is trying to find out who are such kind of people who could be good judge material and who are not doing so well as arguing counsel. So I'll give you an example, Tarun. When I started practice, I started with Mr. L.R. Singh. Now, I had a dream start. On my first day, he gave me 3 matters to argue in Supreme Court. That was in 1990. That was my first day in Supreme Court. And when he saw me argue well, he was comfortable doing drafting and I used to do his arguments. And that was something which really gave me an opportunity to, rise so much as whatever I've been able to do. And I tell these juniors that, if you're ready to work hard in this profession without a godfather also, you can definitely make it. Now, he was ideal to be a judge. Integrity-wise, super, knowledge-wise, excellent. In every quality, but nobody asked him to become a judge. Nobody, I tried, but I was nobody to try at that time. I was a young junior. Probably if it had been today, I would have been of some help. But then I could not, do anything. And the system, missed a person like him. Now, there are hundreds and thousands of people like Mr. L.R. Singh whom nobody notices and who nobody is wanting to find out to be considered for elevation. And these people are also not some, whom you will say to become judge, they will straight away jump at it. You'll have to request them. You'll have to take them with, certain amount of respect and not, in this system where the government sends your name and so the Collegium sends your name and the Collegium and the government keeps it pending for months together. These kind of people would not like to be in that kind of controversy. So if the system is in place where if the government also is part of the I would say, shortlisting. And if the Collegium ultimately picks up, or if the government also in a minority is part of the Collegium with the Bar Association and the veto power remains with the judges, then these kind of people can be, considered and elevated as judges. And that really will be doing a great service to the judiciary, because what is happening today that the level of judges is going down. And sometimes we feel sad when we have to argue before a judge whose intellectual level is not, up to the mark. And that really is, if you ask me, the cause for this delay in judicial dispensation, the increase in the number of pendency. I remember when Justice Kaul was in Delhi High Court, his board, whichever board he handled, used to be almost over. I mean, he used to be current. Now, if the judge is good, if the judge wants to decide, the pendency can be, taken up very, very fast. But if the judge just wants to give dates and he doesn't know, if the lawyers can, waylay him and argue and he's not able to make up his mind, then that results in, the system getting somewhere, failing to the people.
You brought up a very interesting point. There's an unwritten caste and region state quota to elevation of the Supreme Court. Now it is followed, though it's not officially spoken about. Do you think it is good in a democracy that these things are considered that, okay, this caste or this state should have a representation? Or do you think it is a bad thing that this thing is done? What is your view? Because it's not official, it's not written down anywhere. We know that it happens. So your views on it, because you're seeing it for over 3 decades now.
So the caste would be weighing definitely at the High Court level. And I don't think that's correct. It should be definitely by merit, because the higher judiciary, especially the High Court and the Supreme Court, appointment should be only by merit. But you're right, in this collegium system, one of the bane is that if the judges are of 3 different castes, then they try to balance their caste also while making appointments. So that's not correct. In the Supreme Court also, if you ask my very personal view, the Supreme Court, the only consideration should be merit, because ultimately the Supreme Court is laying the law of the land. And
Yes.
whatever the Supreme Court decides, is to be followed by the entire country, including the lower judiciary and the government and everybody. So to give a court, and our Supreme Court is considered one of the most powerful courts in the world, with Article 142 and 32 jurisdiction, everything put together. So according to me, the best only should come in Supreme Court. But while choosing the best, if there is a, I would say, 19-20 ka difference, then you can also look at regional representation. And you can also look at, say, for instance, the minorities and those considerations. But that should not be at the cost of merit.
I want to ask you, you said not at the cost of merit. And from that spawns my question. In your earlier answer, you said about the quality of judges, and sometimes when you argue, it is a kind of a problem. I want to ask you how big a issue this is, or these are exceptions that, when there are, say, about 30 appointments, there may be one odd person who may not be suited but got elevated, those kind of things. Second, the issue of writing of judgments. In fact, during when Ramana was Chief Justice of India, we took up this issue many times because he was very vocal on the issue of writing of judgments. And we spoke about the art of writing judgments. Not everybody it's difficult because you've been a lawyer, now you have to write judgments. Can you reflect on these themes a bit?
So Tarun, the sad part is that the number of or the percentage of appointments whom we find to be below the mark are growing. And that's the sad part. And there are several reasons for that. One of them is, of course, that the Collegium is not wanting to pick up the right people, and there is no effort, and they probably don't have the time, and they don't have the inclination, and they don't do that wide, range of discussions to find out who will be the best. And second, of course, is, as you've seen in the recent past, when government, holding on these names, and then good people withdrawing their names in this back and forth between government and the Collegium. So both these issues are actually combining to ensure that good people are staying back and not getting elevated, and only the mediocre who are people who stay for years together to become a judge after their name having been recommended, and second iteration and third iteration. Invariably, many of them would be of such caliber who are not doing so well in the profession, and accordingly they are clinging to become a judge, and they are waiting that somehow it gets through. But because a good lawyer will, definitely not want to hang in a balance like this, which ultimately affects your practice also. If your name is, if it is known to have been gone for being recommended for being elevation, and it doesn't get elevated, then in that interim period, it affects your practice. So not many people would like to remain in that zone. So to say, for a very long period of time. So this tribe is growing, and that's the disturbing part in our judiciary.
Okay, that tribe is growing. I want to ask you one more thing. Since you've seen this system now for over 3 decades, where do you think we have gone right? What are the things that are good things that have happened in your view? And we should grow on those good strengths that we have achieved.
So, Tarun, I've known of cases where, Collegium judges or chief justices have gone out of the way to find out the right people and convince them. I remember once Dalveer Bhandari told me that when he was chief justice in the Bombay High Court, he identified about 7 names, and all 7 refused because they were leading practitioners. So he said, I'll come to your homes. And he said that you call your parents, you call your wife, and I want to meet all of them. And he says, out of those 7, I could convince 4, and the 4 gave their consent. So that's the kind of effort you require to get the right people to be elevated. And you need to really, really, work hard to convince them. Because I'll tell you, any good lawyer, whether he's arguing or not, even if he's simply drafting, or he's in a law firm, or he's doing, he has good knowledge of law, he is doing a sacrifice by getting elevated, because the money that he will get is nowhere near what he is making in the profession. So to make him expect him to make that sacrifice, at least you have to give it that dignity to him of not him making him run for getting elevated. At least if he should be given that due respect in being considered for elevation, and then his name being cleared seamlessly. And that is why I say that if the government also is part of the Collegium, at least this back and forth will not happen. And once the government is already part of the Collegium while recommending the name, although they may be in minority, and they would have seen all the deliberations that have gone in the Collegium of why a particular name is recommended, even in spite of their reservations. They definitely will not have any further ground to make while issuing the notification. So government, the Bar Association and the Collegium, with the Collegium having veto power, I think is the right way forward as suggested by Mr. Panchu.
Achha, I want to ask you one more thing here. Since you represent thousands of advocates who voted for you and otherwise as the head or as a leader of the bar, lawyers represent clients in different cases. But lawyers can't take up every case because some case is a tax special case, some case is competition law, something is APTEL, which is electricity specific. So they're different and lawyers specialize these days. The law is very vast. But judges, or judging by their very nature, whatever their orientation is in terms of their study, they get to judge on everything. Do you think that is also an issue that need to be looked at during elevation? Because many times somebody who is mastered in a particular subject and even as a lawyer never practiced gets to judge those matters. It's a very complex issue, but could you reflect on it for 2-3 minutes?
So, so what they do in the High Court, and I know for sure that that is definitely one of the consideration, that they have some people from the tax side, they have some people from service law, they have some lawyers practicing from the criminal law. But unfortunately, this is all unstructured. So, there is no system in place that how many judges we have on the criminal side and how many more we need, or how many service law judges we have and how many more we need, how many judges we have on the constitutional side and whether we need more of them. That structure is not there. And that is why the aberrations happen. And when they elevate somebody, they elevate whom, especially of people whom they know, without realizing that we require more people on the tax side and we don't require more people on the criminal side. But Tarun, interestingly, when these very judges come to the Supreme Court, this has been told to me by several Supreme Court judges, including the Chief Justice of India, he said it in a public platform, that they in Supreme Court end up deciding issues which they have never dealt with in their life. And that's a very big challenge for them. The good judges are the ones who want to learn, who will learn from a senior advocate who's arguing a particular subject which they have not, dealt with earlier. But the majority, feel that they know everything, even though that they don't know nothing in that particular subject. And in that process, to show that they know everything, they end up, passing all kinds of weird orders, and sometimes they create a huge problem in that particular jurisdiction. So without naming judges, I can definitely say that criminal law has seen this problem happen in Supreme Court several times, where judges who didn't know criminal law have handled criminal benches and have written such, I would say, bizarre judgments, completely contrary to the basics of criminal jurisprudence, that only later when another judge comes who knows that subject, is able to correct it. So all that also needs to be addressed. And I feel that when you decide to give a particular new subject to a particular judge, there should be some kind of a ongoing orientation program where, there could be somebody, giving a short 2 or 3 day course, so that at least they are not completely, at bay when they start their jurisdiction.
You made a very interesting point. That's why I hold you to it. Do you think at the Judicial Academy, like in the one in Bhopal, there are these orientation courses where we have many lawyers going and teaching? Do you think that should happen more? Because I'll give you an example. We are a $3 trillion economy aiming to be a $5-6 trillion economy. Commercial disputes are having, say, ramification of thousands of crores. Promoters have to pay interest to banks, so they want quick resolution. It gets stuck in Supreme Court sometimes for 2, 3, 4 years. There is no judgment. The banks are facing problem. In many cases, the companies are facing problem because the loans go NPA. So that is a problem. And secondly, if they get in front of a bench who is not oriented to judge that issue in a sense with their background, do you think that we can grow at the level that we are growing India as an economy? If the business and industry is not able to get resolution quickly, either way, I mean, if it gets stuck, then a lot of money is stuck. And then in India, when they sit in London and New York, say, then in India, it goes to court, it gets stuck, my money is stuck, I don't want to invest here. Do you think we should also look at law as a service here? law as a service to society in terms of a service to the industry, because this is not criminal prosecution, these are industrial disputes. So your two bits on that.
Tarun, very interesting point here. And this I've been saying at several forums and several platforms, that we cannot move forward as a developed nation or lead the world if our judicial dispensation does not improve. I've been saying this again and again, and this is exactly what I've been saying. And I'm so glad that you asked me this question. If we want our economy to really grow, we have to have a very responsible judicial dispensation, and especially in commercial matters. And it's so sad that you see, a bank guarantee matter getting stuck for months together.
Yes.
A commercial dispute with regard to an ongoing contract being, scuttled by the judiciary on some very flimsy ground, and with the result that the cost of constructing that particular project goes manifold because of that judicial delay. I mean, these are instances, and instances can be given of such kind of, I would say, errors or flaws in our system, which need to be corrected. And for that reason, the academy at Bhopal or somewhere else can really be useful, where we can bring in people from, say, Singapore, where, these kind of judicial dispensation is much, much better, or from Paris, or from, where the commercial disputes have evolved much, more aggressively than our system, and have them, teach our judges how to, ensure that these disputes do not linger for long. Because the idea is that in doing justice to one person, you end up doing injustice to millions and crores of our nation people. So if a road gets delayed because of a matter getting stuck in court, you can imagine the kind of problem that the particular people living in that area face. If a power unit is stuck up, you can imagine the kind of problems the people in that area face. So these are very, very important issues which have to be looked at a very, very, I would say, with a national perspective and the economic perspective, and then, taken forward. And for that, we really are lacking behind, and we need to do a lot. But if we have good quality of judges, I would say most of these issues automatically get taken up, because even if a judge has not dealt with a particular subject, but if his first principles are right, if his basics are right, then he will know where an interference is called for and where an interference is not called for. And even if an interference is called for, to do it quickly and decide the matter at the earliest, rather than I see judges doing a small pension matter or a small increment matter and hearing hours together on those matters and not giving time to these commercial disputes, which are also before them simultaneously. I think this is doing great injustice to the economy as well as to the nation.
But good you articulated on this issue, because recently, of course, there was this huge discussion. The retired Supreme Court judge told me NBFCs are in a sense going into insolvency because contractors can't pay them, because contractors' payment cases are stuck in court. So, I mean, the ramification on the economy is huge. Good you took it up. I think that's it for now. Thank you so much for echoing your thoughts on this issue. But we'll keep this dialogue ongoing. I think this issue is going to rage in for some more time, I think for a couple of months. I think in a month's time, again, we'll request your presence for this issue. Till then, the issue would have moved ahead a bit. But that's it for now. Thank you so very much for being free, frank, as usual, in whatever you want to say on whatever topic you speak on. Thank you so very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.